Hey everybody, Jared Lyles with Jared and Lyles PC. We are a general practice law firm here in Silver Hill, Alabama, and today we are going to be talking about estate planning. Now this is going to be a two-part series of videos, and in this first video we're going to be talking about a document that most of y'all are familiar with, and that is a will. In the second part of the series, we're going to be talking about living wills and powers of attorney. Now those three documents all together are what we would recommend that somebody gets if they're looking to do a complete estate planning package. That's a will, a living will, and a power of attorney. So starting off today and talking about a will, again, this is a document that a lot of you are familiar with, but what we're going to do is just kind of run through some things that you may need to think about as you're getting ready to do your will. These will all be questions that we at this firm or probably any other attorney are going to ask you. So go ahead and be thinking about, how you want to do these things. Now the first thing with the will is obviously who's going to get your stuff. Okay, you set out who is going to get all the things that you have after you pass away. Now generally in this scenario or in a simple will, everything goes to a spouse, and if not to the spouse, then it goes to your kids equally. That is a general simple will setup. Thinking about who is going to get your stuff, there's two things that generally fall outside of that, everything to this person, and if not, then to this person. And that's specific gifts and charitable gifts. Really the most common specific gift that we see is if we have a parent that wants a certain piece of jewelry or a certain collection or something like that to go to a certain kid. Maybe that child has a connection with it, maybe they share that interest, whatever it is. Be thinking about if you have any specific gifts, specific items that you want to go to certain people. Doesn't have to be kids, it can be anybody. That's one thing. Also, charitable gifts. A lot of people want to give money to their church, want to give money to a certain nonprofit, and that can come before or after, your general gifts. You can give everything to your spouse, then to your kids, and then if everybody else has died, then everything to a charity. Or you can give a certain amount to a charity up front, and then give everything else to your kids or spouse or whoever you want to give the remainder to. So those are just a couple things that you need to think about as you're doing your will. Now, one thing that I do like to point out is when you're talking about children, okay, everything, say your spouse is predeceased you, let's say you're divorced, you're not married. If you give everything to your children equally, I want to be very clear that stepchildren are not included in that. Legally, stepchildren are not children. That may be good for you, that may be bad for you. I don't know what the case is, but you need to know that a stepchild is not included in that division. You can include them, but if you want to do that, you need to make sure we include them and identify them as a stepchild so that they are included in the division with your other natural children. Adopted children are treated as naturally born children, so you don't have to make any special designation or acknowledgement of them. So just something to keep in mind as you list your children. Make sure we know if that's a stepchild or a natural born child. So after you've kind of figured out who's getting everything, the next question that you have to answer is who is going to be in charge. All right, so there's a group of people, there's 2-3 people that you have to pick when you're doing your will, and the first of those is your executor. Now this is the person that's going to be in charge of carrying out your wishes. This is the person that's going to work with the lawyer in the probate court and get your will through probate. Okay, that brings me to something. A will does not avoid probate. Okay, that's very important. That's a common misconception that people have. A will does not avoid probate. It is simply the rules by which the probate is carried out. Okay, so that's very important. But that person, getting back to that, is the executor. That's going to be the person that is responsible for doing this. Now, generally it looks like spouse is your first choice as executor, and then one of your children is your second choice. But it can be anybody. It can be any friend, any professional, anybody that you want to be in charge of that. You can pick that person as your first choice as an executor. Now, we generally recommend that you have one backup as well, and if you can, we like to have those people in different age categories, okay? So if your spouse is roughly your age, your children would be in a different generation. That just tries to protect that one of the people that you choose will still be alive when it's time to probate your will. So the second group of people that we're kind of looking at will be if you still have minor children. We will set out in your will who is going to be given the responsibility of caring for those children. Now, your will does not do that automatically. You still have to go through the juvenile court and you still have to get official custody granted, but putting into your will is going to be a very good indication to that court of who you want to be in charge. So who you want to be in charge of your children, those are going to be the guardians. You will put that in your will as well. Now, there's another group of people, and it can be the same or it can be different, but the person that is going to be in charge of the money, the trustee, the conservator, whatever the case may be, that is going to be in charge of the money to help take care of your kids does not have to be the same person that is in taking care of your kids. We get this all the time. Well, you know, these people are going to be great parents, but I really don't want them to be in charge of the finances. It's perfectly fine. The people in charge of the kids and the people in charge of the money for the kids can be two different people or two different groups of people. That's perfectly okay. So these are just some things that as you're going through thinking about getting a will and what you want to do, these are just some good things that we want you to think about. If you have any questions, if we didn't cover anything with this, please feel free and give us a call. Send us an email anytime, and we'll be happy to answer any other questions that you may have. Make sure you tune in for the second video in this series covering living wills and powers of attorney.